Welcome back to the F***ery Files. Last episode, we left off talking about management agreements, and we got about 30% of the way through the clauses involved in the management agreement before we ran out of time. In this installment, we're gonna give you part 2 of the breakdown of a typical management agreement, what you should look out for, different points to negotiate, and how you can save yourself a whole lot of money on lawyers' fees by getting some of the early negotiations out of the way before you bring it to an entertainment attorney. So let's get into it. Last went off, we went over the typical terms section of a management agreement, how long the agreement lasts for, the initial period, option periods, when and where the management company can exercise those options, and what happens if you release a full-length project right before the expiration of that management agreement. The next section you're likely to see in a typical management agreement is the section that defines the manager's percentage. And it'll typically start off with something like, in consideration of the manager's services defined herein, which it's not very well defined herein, and then it'll outline what the manager's percentage is. A typical manager's fee for any newer or even established act is 15 to 20%. It's likely that when they first throw you the paper, it'll be at 20%. And depending on how much they're getting, so how much leverage you already have, how much you've already built yourself, and how many actual acts they're getting out of the deal. Like if you're a band or a group or a collective and they're getting a whole bunch of solo careers out of the deal, you should be able to negotiate down from that 20%. It is very rare for an artist to sign a management agreement above 20%. The only thing I could imagine is if they're just not looking. And it's very atypical for an artist to sign a management agreement for less than 15% unless they're a legacy artist or they already have a huge career. Now, in this part of the contract, it will define the revenue from which this percentage comes as either the gross compensation or the net compensation. In either case, it's very unlikely that the compensation will be flat gross or flat net. Flat gross would be you make $100,000 off of a tour, you pay out $20,000 in expenses, but your manager gets 15% of the $100,000, not the $80,000 profit that you made. That's flat gross, and it's very unlikely, and if you get a contract that's just flat gross, accounts for no expenses that you might incur, then you're gonna want to not sign that. Don't sign that. But it's also very unlikely that your contract will come to you as just a flat net. Hey, whatever profit you make, you share it with us. And the reason is you could go out and buy 20 grand in jewelry instead of tour support, and you could still say it's a business expense because you only use it to hike up your image and that helps you business. There's a million different things that you could charge as a business expense and leave your manager out in the cold on a bunch of revenue. So what's more typical is that you will have this defined as gross compensation, and then there will be a number of exclusions that they specifically define in the contract. And this is another major negotiating point. What can you exclude from the gross compensation? What expenses can you recoup before you give your manager their percentage? It is typical for any recording costs to be excluded from the gross compensation. So you can recoup any expenses related to recording your work, studio fees, backup singers, guitarists, or whatever, session players. Probably not runs to the store for more blunts, but you get the picture. Then you have money that's payable to any third-party author or co-publisher or writer. So if your distributor allocates 20% of the streaming revenue to another artist because they helped you write it, you don't have to pay your manager 15% of that 20%. You're all good there. Then you'll typically see something that carves out any money paid for sound and lighting or tour support. You're gonna wanna make sure this is really specifically defined, because if they leave out something, it could represent a huge amount of revenue. Touring is an expensive endeavor, and you wanna make sure every cost you might incur in doing so is specifically defined in the exclusions of the gross compensation. Hotels, gas, food on the road, and even gadgets that make the road possible. You're gonna want to include it all. And just like you have authors, composers, and co-publishers revenue excluded based on the performance arts copyright, the underlying composition of any song, you also have the producers and mixing engineers royalties excluded as part of the sound recording, the actual master recording. So whether you're paying out royalties from the master recording, the sound recording copyright, or the performance arts underlying composition written song copyright, those won't be included in the gross compensation. Now, if it's not included in there, you definitely want to make sure you include any money that you have to pay out for opening acts on tour or at any live performances. And that includes sound and lighting and tour support for those opening acts. If you have to pay out anything, you want it excluded from the gross compensation. You typically have exclusions for independent promotion or marketing as part of a label agreement. So if a label gives you an advance to spend on marketing, or they're doing the marketing for you and it comes out of your royalties or advances, then that will be excluded from the gross compensation in most scenarios. And if it's not, you want it to be. Then you have video production costs. Typically, this exclusion will be involving music videos, but we're in the age of content now. So you want all video production costs, all content production costs to be excluded from the gross compensation. Performance guarantees are typically excluded from the gross compensation. I'm not exactly sure why, but it's been on every management contract that I've seen. And it's usually only performance guarantees that are below a certain amount of money. You'll also want financial investment income excluded. For instance, if you make $100,000, you give your manager $15,000, and then you invest the other $85,000 into Bitcoin, and it grows into $150,000, you don't want to have to go back and give the manager part of the $65,000 you made profit. That income should be excluded from gross compensation. Typically, these management agreements will also exclude any merchandising costs. So if you have to do marketing, manufacturing, production, promotion, staffing behind a merchandise arm of your music business, those costs will be excluded from the manager's gross compensation calculation, which is really advantageous. And I think it's left over from the fact that the music industry doesn't understand how much money the merchandising arm could actually be. And then lastly, if it's not included, you should include a carve out for any out-of-pocket expenses for independent promotion and marketing. If you're going to be running your own ads, if you're going to be paying costs on your email marketing and your website and all this other stuff, you want that deducted from gross compensation. And if you feel that it's right for something to be excluded from gross compensation, it should be an expense that both you and the manager share in the pain of, then you're going to want to negotiate that to be included in these exclusions. The next section of a typical management agreement is going to define that the gross compensation means any money that comes to you as a result of or pursuant to a contract or a deal that they help you negotiate during the term. Any contracts or deals that they helped you get into but didn't actually materialize till after the term. So if they helped you get started talking to a certain record label and you don't sign with that record label till after the term expires, they get to share in that as well. Typically, it will say any and all extensions or renewals of that contract. So if you are Bob Dylan and you sign with Columbia Records and that clause wasn't limited in any way, then your management would get their percentage from all of the records you ever make with Columbia. Luckily though, there's typically going to be a sunset clause, which will be up next after this one we're talking about. And typically this section will also include any money that comes as a result of judgments, awards, or settlements that arise as a result of malfeasance or negligence in a deal that they helped you sign. To unpack that, basically it means that if they help you get into a record deal and then the management contract expires and later on you have to sue that record company and you're awarded $100,000, they get their portion of that $100,000. There may also be a section in here that talks about how the gross compensation will include any money that comes as a result of the exploitation of master recordings that were recorded during the term but only exploited afterwards. So if you were in the studio recording a bunch of masters for your next album and then the management contract expires, then you release that album, they still get to share in that revenue. But luckily, at the end of all this, there's typically a sunset clause. And if there isn't, you need one. A sunset clause, which is actually usually not called a sunset clause, will typically define that the manager or the management company only gets this percentage of the gross compensation for a number of years after the management term expires. So to unpack that, let's say that your management contract is for 15% for 6 years with all the option periods if they exercise them. You get to the end of 6 years and that 15% will drop down to like a 12.5 or a 10 for 2 years thereafter. So any deals that they helped you sign, any albums they helped you record during the term, they'll continue to get money from those things for like 2 years after the term expires at a lesser percentage. Then for another 2 years after that, the percentage will drop down. Typically these things can last all the way out to 6 years. What I've typically fought for my friends to negotiate for is a 4-year post-term period. The sunset clause basically stipulates that, hey, for 2 years after the contract expires, you can continue to get 4/5 as much as you were getting before. So if you had 15%, that's going to drop down to 12%. You collect that 12% for 2 years, and then it drops down to something much lighter, like 7% for an additional year. And then for the last year, it's like 5%. That's typically something that you can not only ask for, but get from a management company, especially if they're already asking you for something ridiculous like 6-year post-term period. It's kind of extensive. So I would negotiate this down wherever possible, and if it's not in there at all, you need it included. I would start off by asking your management company to instantiate some kind of legal language that says that they don't continue to reap the gross compensation percentage after the management contract term expires. They're gonna come back with a sunset clause, and then you negotiate them down off the ledge from like a 6-year post-term period, end up somewhere in the middle. This is just a general principle in contract negotiation. You're gonna wanna go for a little bit more than what you need so that you can come back down. Disingenuous, stupid, time-wasting, and a staple of contract negotiation in the industry. Ask for more than you want so that you get what you actually want. This fucking music business. In this same section of the contract that talks about the gross compensation, it's also going to talk about what expenses the manager is allowed to incur that you have to recoup for them. So for instance, if a manager has to fly to LA from their offices in Austin, Texas to go talk with a label about signing you, chances are you're paying for that flight in one way or another. But you definitely want the language here to prevent your manager from making any expenses over a certain dollar amount without your express approval. Written approval. You probably also want the contract to state that your manager can't exceed any certain expense amount per month without written approval. This way, let's say you've got it set up so that they can't buy anything over $100 without your consent, but they could buy like $50, $80 things within a month, and that would effectively be thousands of dollars. So you probably want something in there to say that a certain amount per month also needs to be approved. And there will probably be a couple of other boilerplate type things, such as a clause defining that if you get any stock as a result of your entertainment services, that you share in that revenue with your manager. A clause defining what happens if you should assign your rights to a property the manager gets revenue from to a family member in the event of your death or something like that. But most of the nitty-gritty stuff that you're gonna wanna negotiate, we've already gone over. Typically, there will be a section in or around this section that talks about you hiring a business manager or an accountant, and then how and when your management company or manager might inspect your books to make sure they're getting paid appropriately. So there will be a bunch of language about you have to hire an accountant or a business manager in this period of time. You have to keep these books here, and if we request an audit, then you have to show us our statements in this amount of time. And if we accept your statements as valid, then we'll approve it in this way. There will be a section about material breaches. So if some of the terms of this contract are violated, what happens then? And then there will be a section on power of attorney. Now, if your contract that you're given is entirely pro manager, it's going to grant them power of attorney to sign contracts on your behalf. If it's more pro artist, it might grant them a limited power of attorney to agree to publicity events, uses of your likeness, advertisements, and promotional materials, but ultimately will prevent them from being able to sign an actual contract on your behalf. What you don't want is for your manager to have the power to sign your name on like a distribution, a production, or a label agreement. You need to retain that ability yourself. You need to have right of refusal, is what it's called. You need to be able to say no to things you don't want to do. On the other hand, you don't want your manager to have to bug you to sign off on every single morning radio appearance, every single press photo, every single use of your likeness or logo, and you want them to be able to sign contracts on your behalf for that sort of thing. So you need to reach a middle ground here when it comes to power of attorney. Don't give them too much, but allow them to take care of some things that would otherwise be a hassle for you. There will also typically be a section about the assignment of the agreement. So for instance, if you sign with a manager and then they get picked up by a management company, does your agreement become part of that management company? Or if your management company gets bought out by a parent company, is your contract contract transferable to the ownership of that parent company? In most cases, yes, it is. The manager is going to be able to assign their portion of the agreement to any third party they so choose, and you can't assign your end of the agreement to anybody, obviously. But what you might want to fight for here is that it should be required that the company your manager is going to assign the agreement to be a company that your manager also has a principal interest in. So they're a principal investor in the company, they're on the board of directors, they're a significant part of that company. Otherwise, your manager could just sell your contract off to a third party that they have nothing to do with. And it may be in here that you'll either see or want to instantiate a key man clause. Key man clauses are typical in the music industry, not just for management agreements, but also for label agreements. And that's because typically it's an A&R that brings in a specific artist to a label. They're gonna handle that artist, keep a watch over their debut album track listing, approve and deny tracks for that debut, and they're gonna court that artist all the way through their debut on that record label, at which point a larger team might take over. Now, if that A&R leaves the record label, labels don't invest a whole lot of resources into the artists that were signed to A&Rs that they've since fired or let go or who have left or quit. And that's why a key man clause is necessary. It basically states if this person isn't involved, this agreement's no longer valid. I recently helped my friends instantiate another one of our friends in a key man clause for a management company that that friend works for. So if he quits, they're still on the hook with that management company, but if he gets fired, then they can leave as well. This protects his job at the management company since he's one of the main reasons they're signing with that management company. And if you've got a similar setup or you find a particular manager as part of a team to be very important to your career, you might want to negotiate for a key man clause. If this guy or gal leaves, we're out of here. Next, there will be some boilerplate stuff about how you are of reasonable competence and legal clearance to sign this agreement. You don't already have a management agreement in place, you can sign this contract. There will also be a section that reaffirms the manager's exclusivity with you, and probably a section that states that if you violate that, so if you fail to perform your obligations under the management agreement, or if you get another manager without talking to them, they can extend the term of the agreement, however long they so choose, until it's rectified. Then there might be a period of extra time they get because you did that. So make sure that you watch out for a section like that. Besides some other boilerplate stuff, there'll probably be some language about how notices work. So if you have to give your manager 30 days written notice for any reason in the agreement, this section will outline how that notification should go. Should it be by email to a certain email address or by certified mail to a certain address? Do they have to confirm that they received it? How long do they have to confirm? All that will be outlined in a section towards the end of the agreement. And there will also be a clause that talks about which state the agreement shall be enforced in. And this is kind of important. For instance, if your management company is in Austin, Texas, or their lawyer is in Austin, Texas, more importantly, it's likely that this section will state that the contract is enforced under the laws of Texas. But that means that if you ever have to sue your management company for any reason, you're flying out to Texas for those court dates, man. What I would do is negotiate for this to be in your home state early on. You don't want to get to the finish line after fighting them tooth and nail on every little point, and then you have to deal with this. Deal with it first and foremost. Make it in your home state if they're going to let you, because there's a lot of other stuff you guys are going to argue about, and you don't want this being the straw that broke the camel's back. After that, there's probably just boilerplate clauses, something else about severability, something else about the agreement being enforceable under certain conditions, but all the main points, the points that you might negotiate over, we've covered. I hope by now you understand what a pro manager contract looks like, what a pro artist contract looks like, all the terms and stipulations that you might want to include, and I hope you're a lot more prepared to negotiate your own deals when it comes to management moving forward. Please use this video as a reference guide, and please don't be afraid to do a lot of this negotiation without an entertainment lawyer. I know most people are saying go out there, get a lawyer right away, but I wouldn't. It's not that hard to understand these contracts once you know how to read them, and you can get a lot of the negotiation out of the way before you bring in a certified law professional to proofread your work and make sure you're not missing anything. If you're paying a lawyer for all that negotiation, it can get pretty high, especially if you're just starting in your career. So instead of like hiring a lawyer to look over the first draft of it, send back some revisions, get into a long negotiation, run out of money, and not have any money to hire a lawyer at the very end, I just wait till the very end to hire a lawyer, hire them to proofread it before you sign, make sure everything is how you want it, make sure you didn't miss anything, and then sign. With that said, I've been Circa for Full Stack Creative. This has been the Fuckery Files. Management Agreements 101 and 202. If you like this video, please like the video and subscribe to the channel, where we'll be dropping more music business and music marketing advice videos every single week. And perchance, if you were so brash as to do it, in that circumstance, I would see you in the next audiovisual presentation. Peace out, and always, always get it in writing.